Court is resumed. Please be seated.
Good afternoon, all. Well, for the record, there was a terrible snafu, as they say.
Thank you, Justice Hennessy. Very quickly, I want to address the order sought by Canada. And the main point I want to address is where we differ with the contingent interest First Nations on the requested order. Canada agrees that on the terms that the contingent interest First Nations obtain a declaration of their shares, and we all agree on what those shares are, that those shares are to be distributed upon further orders of the court, and that motions can be brought by the various contingent interest First Nations at separate times, if that's what they choose to do. Canada agrees with the contingent interest First Nations on that. The only area of disagreement is the contingent interest First Nations are looking for an order from this court that those shares attract interest at the post-judgment interest rate. Canada's position on that is that the interest rate should be determined by the court that grants the order that the funds be paid out. That will give flexibility and the opportunity for
Flexibility to whom?
to the court and the parties.
Okay.
Because each of these First Nations has a unique claim. And it may be the case that their resolutions happen at different times and on unique terms. And ideally, these resolutions will be negotiated. And in order to give flexibility to the parties, the First Nations and the Crown, but not just the Crown, in order to give flexibility to the parties, the issue of the interest rate should be left. It shouldn't be a matter that's ordered now before any of these contingent interests have yet established their interest or resolve their Aboriginal title claim. We need to keep open the possibility for flexible resolutions. We just don't know what the future holds with respect to how each of these individual First Nations might choose to address their claims for Aboriginal title versus these shares. And leaving the issue of interest allows for the greatest amount of flexibility. And I draw this analogy not lightly. It speaks to the principle of renewal in my submission. And of course, I'm sensitive to what my colleague, my friend, Mr. Worm, advised us about the need to be respectful and cautious about using those terms when we talk about Anishinaabe principles and understanding them the way that the Anishinaabe do. But I would say that the concept of renewal, I think, does come into play here. There needs to be flexibility for how these future claims are going to be resolved. That does not mean that the First Nations or a First Nation can't argue when it comes before the court, if it comes before the court to get its share, that, hey, it should be the post-judgment interest rate. But maybe at that point, the First Nation might want to make an alternative argument, or maybe the parties will have resolved it and the order will be on consent.
There are some who might say that the biggest issue in this trial is the interest rate.
And that can definitely be determined and considered by the
So we're having a
judge.
whole trial because of the interest rate. Is there not some benefit to having that matter dealt with before one takes into account all the things that each party might want to include in the consideration?
Well, that
Has a certain attraction, doesn't it?
I still submit, though, Justice Hennessy, that no one is precluded from making the argument that it should be the post-judgment interest rate, but we need to remain flexible about the future because the specific interests of these contingent interest First Nations are unique and complex. Otherwise, they would have been resolved by now, I submit. So I just submit that it allows for no party, including the First Nations or any one of them, is going to be tied to an order made now for the post-judgment interest rate when in potentially 15, 20 years' time, it may be a different rate that they're looking for a different reason.
Well, if they're asking for the post-judgment interest rate, they can't be looking for a different interest rate then. right? This allowing flexibility is only allowing flexibility to the Crown. The First Nations are not asking for it,
Well, I submit,
right?
and all I submit, Justice Hennessy, that there may be
I just want
alternative.
to say, you're not standing up here asking for something for the contingent interest First Nations.
In fact, I am, Justice Hennessy. I'm asking, I am. And, you know, I am suggesting that the contingent interest First Nations, by taking the position that they're taking, that the interest rate should be the post-judgment interest rate ordered now by this court, they are removing the possibility for, in my submission, respectfully, for renewal of the relationship. And that's my submission. It doesn't mean that the First Nations can't seek that interest rate if they decide to do that at a later date. I'm just suggesting to you, Justice Hennessy, that any order that's made today restricts the First Nations as to what their position might then be in the future. It restricts how the First Nations and the Crown might come to a resolution of compensation owed in what could be different circumstances than those presently before the court. But the only other point I'd make on that is, I know my friend said, well, by setting an interest rate now, if you don't set an interest rate, there will be an incentive on Canada to delay resolution if it's not held to a specific rate. My answer to that, Justice Hennessy, is Canada would be taking on the uncertainty. There's benefit to the certainty of the post-judgment interest rate. There's benefit to that certainty. And so it's wrong to assume that it's better for Canada not to have that certainty. Canada's submission is not necessarily to Canada's benefit either. Canada's leaving open, taking on the risk, leaving open the possibility, because Canada sees value in flexibility for the purpose of renewal.
Are you also saying it is a matter of dispute, and in a matter of dispute, the goal of renewal is to have the parties come together and work it out rather than have the court make a determination?
Yes, and that's to the benefit of both parties.
But yes is the answer?
Yes. I have other submissions. I suspect my friends from Ontario might address them about why, because they did in their written materials, why the post-judgment interest rate is a little problematic, because we're not in a post-judgment situation. Judgment has not been rendered and may not be rendered for another 10, 15 years. So on that basis, the post-judgment interest rate might not make much sense. Do you understand my point about judgment not having been rendered?
The amount will be fixed.
Yes.
There will be a judgment for an amount. It will be fixed in 2025.
It's not a judgment, though, because it's just contingent. The First Nation some of the First Nations may indeed pursue and succeed on their Aboriginal title claim and not make a claim at all to this amount that has been declared as their contingent interest. It may not become payable at all. They may take an alternative route and receive alternative compensation on an alternative basis. And it's possible that in negotiating that alternative compensation, it's possible the parties may wish to take into account what might have happened if they had accepted the annuity payment. This is where we need flexibility for how any resolution with the contingent interest First Nations will play out. And that's where I get to the point that, number one, there is no judgment here. We're not in a post-judgment situation. And number two, let's maintain flexibility to allow for renewal. It's not at all prohibiting the First Nations from deciding, if they do at the time when they seek their order. And the order may be, this is an order on consent that there is no, this set aside share is not payable. That may be the order.
Would I be wrong if I called it bargaining leverage?
In what? I don't understand your.
You say that in 15 or 20 years, the contingent First Nations may be in a position where they are weighing one offer against what they might have had in by taking their contingent interest. So I thought that's what you were saying.
No, I'm not speculating as to that, Justice Hennessy. I'm not speculating as to whether the First Nations are going to have to weigh one or the other. I'm not speculating about what future negotiations might look like.
All right.
What I'm saying is that we need to leave open, we need to leave open the utmost flexibility. And that's consistent with the principle of renewal. Let's leave open the utmost flexibility and wait and see how these issues are determined. Wait and see whether any of these shares are actually payable. And I get back to my point. It's not at all precluding the First Nations from, at the time that they do actually seek, if they do seek payment of these shares, they can then, of course, argue for the post-judgment interest rate. In fact, they may argue at that point for a higher rate. Perhaps the band trust account will be higher at that point, and they may want the band trust account rate.
Well, you don't have to argue on their
Okay.
behalf. They're arguing on their own behalf.
All right, thank you.
They're totally asking this court for a certain rate.
I do think it's an honorable position for the Crown to take, though, that Canada is willing to take the risk that that might not be the most favorable rate for the First Nations in the future.
Okay.
And that is part of what is motivating Canada here. It's not just self-interest. It's a genuine interest in maintaining flexibility for the benefit of both parties in their negotiations. The other orders that Canada seeks, we've already been through. You'll see it at the end of Canada's factum. Canada is seeking an order from the court that the liability of Canada and Ontario is not joint and several, but that each is separately, severally, and directly liable to the First Nations. And finally, with respect to the question of if this court were to find that the $3.6 billion plus cost was not liberal, just, and honorable, Canada submits that this court should not substitute its own decision, but should remit the matter back to the Crown for redetermination with directions if the court determines that necessary. The Supreme Court left that up to the court and did not appear to favor one result over the other, whether it's to be remitted back or to be determined by Your Honor. The Supreme Court did not favor one over the other. Canada is suggesting that the appropriate remedy would be to remit it back to the Crown, in keeping with the fact that this is a complex polycentric decision that requires expertise that the executive branch has. And those are my submissions.
Thank you very much.
Thank you.
Bonjour, good afternoon, Your Honour. Richard Ogden, Indigenous. I appear for His Majesty the King and Right of Ontario with David Rankin, Susan Keenan, Brody Noga, and Mohammed Salama. I would like to start by saying, if I may, through the court, Chimigwech to the Red Rock Indian Band, Pingwi Nyashi Anishinabek, and Fort William First Nation for hosting ceremonies and feasts to support the hearing. I would also like to thank, through the court, them and the other First Nations of the Robinson Superior Anishinabek for welcoming us onto their traditional territory, and the chiefs, councillors and elders and other community members who have attended this hearing. Thank you, Your Honour. I would like to update the court about payment of compensation. Ontario recently made past compensation payments to 5 of the 6 beneficiary interest First Nations. Ontario anticipates payments to Kiashkizaging Anishinabek this week. Ontario also recently made payments to the Robinson Superior First Nations 12 First Nations of $20 million in aggregate to cover outstanding legal costs up to January 27th. This is in addition to money provided throughout the proceeding in the form of court costs and through the recent engagement process in the form of capacity funding. So that $20 million is in addition to previous court costs and capacity funding. I've handed to Madam Registrar 2 hard copies of Ontario's oral compendium. We'd sent digital copies to my friends. One hard copy is a courtesy copy for Your Honour.
Thank you.
The other we asked to be marked as the next lettered exhibit F, I believe, in keeping with the practice in this review.
Is it F or E? Oh, oops. What do I have as E? Is D not Canada? Thank you very much. Exhibit F it will be.
Thank you, Your Honour. I will be referring to the case centre numbers at the top right within my compendium, but I'm willing to be obviously directed by Your Honour as to how you prefer references.
I'm quite happy with that. If you always proceed by telling me the tab.
Yes, okay.
Thank you.
I'll also this afternoon refer to the plaintiff's oral compendium. I've handed to Madam Registrar and provided to my friends an outline of which counsel for Ontario will address which topics. We anticipate that we'll be about a day and a half. And so we may have a conversation, Your Honour, this afternoon about how we're proceeding. I'll take about 2 hours of the court's time, Your Honour.
Thank you.
I have 3 main submissions. The first as to the nature of the compensation decision. I submit that the approach of the plaintiffs to past compensation is not possible under the Restore Treaty interpretation. It's my first main submission. Not possible under Restore. The second is that Restore directs the parties to Ontario's approach. And third, Minister Rickford made a determination in accordance with that approach. I note, of course, that Minister Rickford made his determination and provided his explanation, and Ontario has paid amounts for past compensation without prejudice to Ontario's position that Canada is the Crown entity responsible for setting and paying annuities. The Minister acted to ensure there was no delay in payment. Now, in his explanation, Minister Rickford reserved his rights against Canada. It's Ontario's submission that the Crown allocation issue is not stayed presently. Ontario is still seeking a judgment on Crown allocation. There is no prejudice to the First Nations in the delivery of that judgment. I said the Minister reserved his rights against Canada. We have no instructions, of course, and no information beyond that as to what the Minister may do on receipt of such a judgment.
The current claim is Canada against Ontario, is it not?
Yes,
Or is there a cross claim by Ontario?
I think just Canada against Ontario.
So there's no claim, there's no outstanding claim in this litigation.
That's correct. Yes.
Thank you. So you have no instructions, but there's nothing outstanding. Thank you.
My first made submission, Your Honour. I want to start by taking you to the plaintiff's oral compendium, which is marked as Exhibit A, tab 11, page 143. Tab 11, page 143. And you've been brought to this table a couple of times already by my friends.
Yes,
You see a table headed Table 8.
yes,
The third row, which is the one I'd like you to focus on, please, is NCRR plus 25% of rents in excess of NCRRs.
yes,
I brought you to this because Ontario has, for the purpose of this past compensation, looked at NCRRs plus 25% of NCRRs, but 25% calculation or determination, sorry, for indirect benefits. And then you can see on the left column figures for different percentage sharing at the band trust account rate. Mr. Solomon, can you just take it up to show the top of the table, please? So the left-hand column, band trust account rate, and you see 100%, 84%, 75%, 50%, and 100%, 4.6 billion, down to 50%, 2.3 billion. And in the two columns on the right, which are band trust accounts to 9051 and 6040 after,
yes.
and then a full 6040 the whole way through, you see much larger numbers on the right two columns than on the left column. And I want you to take two things from this, please, Your Honour. If you look at the figures on the left at the band trust account rate, Ontario's figure of $3.6 billion compensation sits comfortably with those figures. And that's especially so when one appreciates that Ontario adopted the government bond rate. Now, over 175 years, that's slightly less than the band trust rate, and so would give slightly lower figures. Further, yes?
I'm just trying to see what you said about that and remember. What is less than the BTA?
Government bond rate.
Government bond rate.
Slightly less. Over the long term.
Got it. Thank you.
And then these figures in the table reflect Mr. Hutchings' approach to NCRRs. Ontario disagreed in many respects with Mr. Hutchings' approach. And so again, Ontario's approach to NCRRs gives slightly lower figures than the figures in the table. The second thing to take from this is that the big difference between Ontario's number, 3.6 billion, and the other numbers on the right side of the table is the bring forward rate. That's what causes the big difference.
Which is what I put to Ms. Evans. Is that
Yes.
what this case is about?
It's one of the things, and I'm going to explain to you how Ontario got to its bring forward rate and how the plaintiff's approach is not correct. So I'm going to do that in this first big submission here.
But I was just asking you really about the significance of the bring forward rate compared to all the other issues that are before us.
Well, it's there with share. And I'm going to refer to Mr. Schachter's 3 issues
Okay.
in slightly different terms. But overall, Ontario's number is within the neighborhood, 3.6.
Well, you might even say it's within the neighborhood on different sharing positions.
Yes, although we take a quite different approach to the sharing, a very different approach. And
Okay.
so I don't want you to focus on the share at that point. The
All right.
point is just globally looked at, that the court should have some comfort about 3.6 fitting in there if you accept Ontario's approach to NCRRs and accept Ontario's bring forward rate. So the court should have comfort if Ontario accepts those 2 things.
If Ontario accepts,
This court should have comfort if this court accepts Ontario's bring forward rate and Ontario's determination of NCRRs. So maybe take.
but you're not providing me with a comparable chart with Ontario's approach to NCRRs.
No, because we take quite a different approach to that.
Right, but when you say the court should have some comfort, if I accept Ontario's approach to NCRRs, but you're not asking me to. You're saying I should take some comfort if I accept Ontario's number, because Ontario's NCRRs would have been less than these numbers.
Yes,
Okay,
yes. But we don't. This is just to indicate that if you take Ontario's NCRRs and bring them forward at a low rate, they're close to what the plaintiffs say should be done. That should result if you take the NCRRs and bring them forward at a low rate. So this brings me to Mr. Schachter's 3 big issues. I'll probably take it now. First, the net benefits the Crown actually captured. Now, Ontario agrees with this description of the issue. The first is the net benefits the Crown actually captured. Second, Mr. Schachter said the share of net benefits that should have been shared by way of augmented annuities. Those were his words. And Ontario agrees that the question is what to share, but Ontario disagrees that the question is what should have been shared. So Ontario agrees the question is what to share,
yes.
but disagrees that the question is what should have been shared. This is determining.
This is the rents question.
No, this is the question as to past compensation as a whole. And Ontario takes a present approach, look at it from the present, and the plaintiffs say look at it at particular points in the past. So that's why they say what should have been shared. Now Ontario looks at it from the present and says, okay, the share is a question, but really share is the result of how much money
Actually
is paid.
captured.
Yes. So that's why we disagree with the should have been shared part of the formulation of that issue. The third issue, Mr. Schachter says, is what losses were caused and the bring forward rate. Ontario disagrees that deciding compensation requires assessing losses incurred. Mr. Schachter chooses a bring forward rate that reflects his view that one should bring forward losses. But we do agree that choosing the right bring forward rate is crucial to determining compensation. We just say we're not bringing forward losses.
It would be, I think, better if one doesn't personalize this position. It's the plaintiffs and their
Certainly,
position.
yes. In my submission, I'm going to swap the two of the three issues. So first issue, net benefits. Second issue, bring forward rate. Third issue, share. But there's a fourth and more important issue, Your Honour, which is the standard of review. Now I'm going to defer to Mr. Rankin on the standard of review. He will tell you the correct law on standard of review. And return to the first big issue though. The plaintiffs agree with Ontario adding 25% to NCRRs for indirect benefits. Counsel for the Huron interveners said that the inclusion of indirect benefits might be a question of principle, not owed deference. Counsel also said that the calculation of underlying NCRRs, not indirect benefits, but the underlying NCRRs, as counsel for the Hurons, was something to which this court does owe deference. Counsel said no difference on whether indirect benefits are included, but difference on the calculation of the underlying NCRRs. And counsel for the plaintiffs disagrees with that submission about difference on underlying NCRRs. Ontario's submission is that difference is owed on both, but specifically here, underlying NCRRs. So where does that take us? If the court agrees with Ontario and with counsel for the Huron interveners about difference on underlying NCRRs, and if you accept plaintiff's submission that it's proper to add 25%, Ontario's determination, proper to add 25% for indirect benefits, then that takes off the issue, takes off the table issue 1, net benefits. That's where the court goes, makes those two determinations.
You say there's no need for a court for a finding on that.
Net
On underlying
benefits.
Well, I'm saying that in terms of how the court is going to get to the answer, the court can say that issue is resolved. If the court is going to have to make a decision, but no finding, do you mean finding as to law or fact, or do you mean?
Yes, I asked Mr. Schachter, are you asking for findings of fact?
We're not asking for findings of fact. And Mr. Rankin's going to talk more about that in terms of what the court's role is on the review.
Mm-hmm. But you are saying, I thought I understood, if the court agrees with Ontario.
As part of the reasoning to get to.
NCRRs.
Yes.
And the Hurons.
Yes.
And accept the plaintiff's position, that's proper to add 25% for indirect, then that, I think your words were, takes off the table net benefits.
Takes off the issue of net benefits.
The issue is not outstanding.
Correct. The court can move on to issues 2 and 3, which are share and bring forward.
I'm happy to do this in reply, but my friend has mischaracterized my position and I want him to have an opportunity to address that. So I can either clarify it now or wait.
I'm moving on, Your Honour. I'm sorry for mischaracterizing it. It doesn't matter. The point is, if the court accepts that position that I've stated, then we move on to the next two.
Your risk. If
That's
if
fine.
the Hurons add something to it, then
Thank you.
you're on notice. Thank you.
The two issues, the bring forward rate and the share. Now, as I've just said, the bring forward rate depends on what you're bringing forward. And this is where we contrast the two main approaches of Ontario and the plaintiffs about what you're bringing forward. Ontario's, well, sorry. I'm going to call the plaintiff's approach the summation approach, because it involves bringing forward past augmentations that they say should have occurred and then summing them up. That's why I call it the summation approach. Bringing forward past augmentations that should have occurred and summing them up in the present. Ontario's approach is a present-focused approach with one big augmentation decision in the present. So those are two contrasting approaches.
When you one big augmentation, do you use that word interchangeably with the word compensation?
The decision is as to the amount of compensation. So it's an
Ontario's approach is present focused with one, you call it a big augmentation, or can we, I ask, is that interchangeable with compensation decision?
yes.
Okay.
So this summation approach that the plaintiffs advance is not possible under the Restore Treaty interpretation. The plaintiff's approach is to share net benefits in the past and then bring them forward. Ontario does bring forward net benefits, but it doesn't determine a share in the past. It brings them forward, makes a decision as to what to do with those net benefits in the present, and then you end up with a compensation amount, and that can be expressed as a share. But the expression as a share is an end result. It's not a stage for Ontario in the analysis. It's just another way of describing the amount. These are you're talking about the rows, the 4 rows, 100%, 84%, 75%, 50%. When you talk about shares, is that what you're referring to? Yes, or my friend, the plaintiff, said 130% for Ontario. So
Right.
It's just another way.
So those share percentages, you say that's not, Ontario doesn't look at that. At this point, it takes that into consideration in determining a global amount?
Doesn't take it into consideration.
Oh.
It's actually just a description of the global amount as a result.
Okay.
There are other things that Ontario takes into account, but not share as such, not in the way that Canada does.
All right.
These two approaches are the only two ways to decide the compensation. You either do what Ontario does, which is augment the annuity now or all the past in one go, Or, as the plaintiffs do, you can augment it multiple times in the past, bring them forward and add them up. So the main problem with the plaintiff's summation approach is that we don't know what augmentations would have been in the past. We don't know, firstly, what period would have been used between augmentations. We're still said from time to time in paragraph 197. More importantly, we don't know what polycentric decisions the executive would have made at each occasion in the past. Such polycentric decision-making is hard enough when done in the present by the executive, but the past is a foreign land. And I respectfully suggest that this court knows it's hard enough to determine who said what to whom and when in the historical past. I submit it is impossible to know what choices historical actors would have made when weighing multiple factors. And for that reason, no one here actually asks this court to go back and find all the specific differing augmentation decisions that the Crown would have made at different times in the past. That's one way of doing it, and I'd put it there, even though no one advances it, just to show you that that's one way the court could do it, but that's not possible. So we move to the next way of determining past augmentations, which the plaintiffs advance. They ask this court to accept what they call a proxy share. My friend used that term last week. That is, for each supposed past augmentation decision, a certain percentage is applied to net benefits for that period. And so goes the theory that proxy percentage gives the augmentation that the Crown should have made or would have made for that period in the past. But the problem is this proxy percentage has to be the same for all past augmentation decisions. Now, my friend for the plaintiffs said it doesn't have to be the same. I'm going to tell you why it does have to be the same. Different proxy shares for different times in the past would require a reason for a percentage to be higher or lower at different times in the past. You're going to have different proxy shares. You have to know which one to apply at which stage. Now that meets the same polycentric difficulty. We don't have a basis for choosing different percentages for different periods.
I wonder if I have a different understanding of the plaintiff's position. And that is that it is not a set of numbers to achieve a mathematical conclusion, but rather it paints a picture so that the court can do an assessment. So that these are multiple scenarios.
Well, that runs into, I think, the problem of deference. And I'm going to explain what I did take plaintiff's submission to be that there is one share for the past. And that you then apply that to net benefits and bring those augmentations forward. That's the key part here. We don't, I think, disagree on that. And your question as well, there are multiple potential percentages to apply. But then there's the question of, firstly, can you do that? Because you don't know which percentage to apply in different parts.
That's only if you're trying to arrive at a conclusion, a mathematical conclusion that it's a problem that we don't know what to apply. So what we have here are 4 percentages, but I'm sure there's no quarrel between 100% and 99%.
Right.
Or there's no quarrel between 50% and 51%. The purpose wasn't to give a number by which there could be a mathematical formula. I think you started by saying the question of net benefits or crown benefits is no longer outstanding. So then we have share and bring forward rate. And you are telling me that the plaintiffs you are pointing out the problems with the plaintiffs using a particular share and why you can't use a particular share year after year or not knowing about the past. But it's not my understanding that the plaintiffs are asking the court to apply a particular share to arrive at a particular number anymore.
Well, they show on the table different particular shares.
Yes.
But and so then they bring those forward and they say, well, here's a range.
And here's what would happen if one did this. And so I thought they brought me to these numbers to show me, as you did when you started, to say Ontario's approach would fit comfortably within these ranges. And the plaintiffs say Ontario's approach or Canada's approach does not fit comfortably in any of these ranges.
And their approach assumes that it's possible to have these numbers in the past and bring them forward. It rests on the proposition that there are augmentations that would have or should have been made in the past, and then they bring those forward as different numbers for a range. But the proposition that there are augmentations that would have or should have been in the past is one I submit the court can't accept.
Oh, let me see if I get it now. What you're saying is that there's no zero here, or there's nothing between 0 and 50, that there's a possibility in your mind that there could have been a year or 2 years or 10 years or a period for which there were no augmentations.
Yes, and we don't know. So we don't
know that.
We don't know. We can't weigh, but we can't choose between the 50 or the 75 or the 80 or the 25 because we don't know. And so we can't actually engage in that exercise. We can't say, well, here it is. These are the augmentations the Crown would have or should have made, because we can't go back and make them. It's not possible to go back and make them. And so Mr. Schachter said, well, what I asked the court to do is to accept a 50-50 share based on game theory. Sorry, I said Mr. Schachter, my friend for the plaintiffs.
Or the plaintiffs, yeah.
So you either have to allow the Crown to decide the share with deference to the Crown, or there's no difference. And the court chooses a share that it applies to the past, or many shares that it applies to the past and brings them forward. But my friend for the plaintiffs said the court should start with a 50-50 share. And the court would owe no deference to that share, he said, because it's part of the scope of the treaty right. I'm going to show you the transcript from the 4th of June, which is hearing day 3, at page 420 line 20 and on to page 421.
Is this in your compendium by?
Sorry, Your Honour, this is from this hearing.
Yes.
It's not in the compendium.
Got it. I'll just make a note then.
So yes, day 3, June 4, page 420. But I'll read it out. Included in the findings of fact, we think, would be you would need to make rulings on the form, level, and aim of the sharing that the augmentation clause requires. Respectfully, this critical variable, how to come up with the share of the benefits captured in any 1 year in the past, remains part of the scope of the treaty right itself, and is a matter for either the parties to agree upon to define, which they have not been able to do, or for the court to decide upon, just as the Supreme Court of Canada says you must.
Would you mind taking me back a couple of lines before, please?
So start at line 20.
Thank you. Form, level, and aim of the sharing?
Yes, and so that's referring to paragraph 180 of Restore,
Yes.
which we can take you to in tab 1 of my compendium,
Yes.
page 8442. Right, That's not it, no? Yeah. So paragraph 180.
Eight, 442 is not the chart. Not in mine.
Right one. So that's paragraph 180, 8442.
Oh, 8442 is is paragraph 180.
Okay.
Sorry, I was just looking for the chart.
Okay, thank you. I'm going to read this as well, Your Honour, because it's
Okay.
important. As the Court of Appeal majority stated, quote, the parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing that the augmentation clause requires, end quote. Paragraph 323. They added that this exercise should be, quote, led by the treaty parties' shared goals, expectations, and understandings in 1850, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, identified by the trial judge, and the Crown's commitment to being both liberal and just. This is the task of reconciliation. I agree with these observations, subject to the discussion below regarding the appropriate remedy. So my friend took you to this in support for the proposition that the court here can decide the share of benefits captured in any 1 year, because that is part of the scope of the treaty right. So this is support for that proposition. And I say it does not support that proposition. This paragraph appears in the middle of the Supreme Court's discussion of treaty interpretation. The court was describing what will happen in the future, not what should happen with respect to past compensation. And that's apparent from the last sentence. It makes sense that a court might determine the level of sharing in a future augmentation, because if the parties can't agree in a particular future augmentation, then the Crown decides, and it might then go to the court on a review. And whatever the court decides on that review will have set the level of augmentation for that period.
Is it your argument that the court here says that the judge at stage 3 must determine the share, and that therefore is a reference to the future? Because what the says, what the Supreme Court says this court must do is determine the form, level, and aim of sharing. So does that tell us that it can only be future oriented? Maybe it is at when you use the word level.
Well, I think though the court was aware that there was more to this proceeding than the review as to compensation, which is what the Supreme Court is referring to in the last sentence. And so the court says subject to what we have to say about remedy. But it's my main point there is that this comes within the interpretation section. And so it applies to all future augmentations. And it makes sense that a court might determine the level of sharing in future augmentations. Second point, in respect of scope of treaty right, is that a finding as to scope is a finding of law, not of fact. A proxy for a past level of sharing that's described as a treaty level of sharing, part of the scope of the treaty right, is inconsistent with Bristol. Bristol said that the augmentation clause was not a promise to pay a certain sum. I'll take you back to Compendium tab 1. Bristol paragraph 289, which is 8460. Under the heading, the nature of the treaty promise. So that's 8460.
Thank you.
289. The nature of the treaty promise. The court says, the fact of the matter is that the augmentation clause is not a promise on the part of the Crown to pay a certain sum of money. And then over to paragraph 301, page 8467. It bears repeating. It's the fourth line down. Yet it bears repeating that the augmentation clause is not a promise to pay a certain sum of money. The court also said, I won't take you to it, but paragraph 182, the court referred to general notions of Crown discretion and the sharing of future revenues. Paragraph 182, general notions of Crown discretion and the sharing of future revenues. Now, Your Honour raised this fixed share issue with my friend.
Yes.
Whose response, I submit, did not resolve the problem. There's no way around this problem, Your Honour. There is still finding that the treaty promise is not to pay a fixed percentage of a certain sum of money as a dead end to the plaintiff's compensation theory. But my friend said that we can start with a share to apply to the past, a presumptive share, which could change depending on present circumstances. I'm in the court's hands as to whether we continue until 4:30 or we take a break or we do whatever.
We started an hour ago, right?
Yes, well, slightly less
How are you
perhaps,
doing?
but
Huh? Taylor, how are you doing?
No issue.
If the court is okay, I would just go straight through.
thank you.
Thank you.
That doesn't, a presumptive share doesn't work because the Crown doesn't start with a fixed share, say 50-50, and then justify if it can't meet that share. It's not what Restore says. That would be a results-driven approach. And my friend said that polycentric demands in the present, for example, fiscal pressure, might mean that the Crown's share has to be greater. In terms of sharing the present, less past compensation. But we would then just be changing the share according to how much the Crown could pay. That's not a principled determination of share, of a proxy share. That is results driven. The proxy share would depend on what the Crown pays. And what one would actually be choosing, when one was choosing a proxy share, is what the Crown pays now, not the share that applies to past augmentations. So the only way to get around this results-driven approach is to have a fixed share that applies to all determinations. But Restore said there's no fixed share, so you can't get around it.
Did they mention fixed share? Did they mention fixed amount?
No, they said it's not a promise to pay a certain sum of money. I think they took from that the certain sum would change across time. So they weren't talking about a specific dollar amount, but that the amount is determinable in advance, either a share or some other means.
Okay.
And they did say that sharing is to be guided by principles and so on, which I'll get to. Now, I submit that the plaintiff's approach is ultimately dependent on the calculation of net benefits, and then takes us back to Ontario's approach as the only way to determine compensation.
Ontario's approach to,
As the only way to determine compensation.
Ontario's approach to net benefits?
No, to past compensation.
Okay.
I do say, though, that we end up in a situation where net benefits becomes the starting point. So if we have this summation approach and you have a proxy share and you adjust the proxy share based on how much the Crown can pay in the present, it really depends on the other half of the equation, which is the net augmentations brought forward. So if we're using a proxy share and applying that to the past, but we get the proxy share from present Crown ability to pay, Crown ability to pay depends on how much money is brought forward. So it's circular. If we're bringing forward past augmentations and then adding them up, Crown can't pay them, we reduce the share, we get a lower proxy share, we apply that to the past augmentations, bring them forward, and so on. It's circular. So the only way to get past this is to bring forward net benefits. And that's Ontario's position.
And you say that the approach of just taking share out of the early part of the determination. So you say Ontario's approach is take net benefits, apply bring forward rate, include polycentric considerations, determine share.
Yes, although not so much include polycentric, but different factors. Bringing the net forward benefits forward is one of the factors. There are 4 other factors. And then the polycentric is how you weigh all those factors against each other.
All right. So you say to get a number, you take net benefits, which I believe you have said is pretty much not contentious.
Well,
The
net benefits, the NCRR is plus 25%. Now, obviously, there's a disagreement about the base NCRRs, whether we have Mr. Hutchings' approach or Smart and Bodeways or a mix. We say there's difference. We say there's agreement. I don't want to, let me just say Ontario's position is that difference should be owed to the determination of NCRRs.
and in your chart, what numbers are you using?
The chart that
Yes.
the plaintiff's chart, we're not using numbers up there. That's just to show you the numbers are set out separately in the minister's explanation. So that's just to show you that if you have a low bring forward rate, you get to low numbers. It's sort of obvious there. And if you agree, you have NCRRs plus the 25%, which is what Ontario says, then you get to low numbers that are in the same sort of neighborhood.
Can you take me, please, to chart 8?
Yes?
Or just tell me where it is in the compendium?
Yes. That's the plaintiff's compendium, Your Honour,
Got it?
which is tab 11, page 143.
So these are Mr. Hutchings' numbers.
Yes.
And so using Mr. Hutchings' numbers, which Ontario says we don't accept, you don't accept those numbers.
Well, we don't, but we actually don't, the minister didn't accept Smart Bodeway numbers either. He sort of took some from each and adjusted them. So yes, we don't accept the Hutchings numbers.
But you don't, but I thought you were saying that there's not a real big difference. Or certainly Canada says that. Do you disagree with that? Mr. Rankin's trying to help you. But
Can't read what he's writing.
in the old days, I thought that would be a disagreement between counsel, but now it's just.
We're not used to writing with our hands.
The penmanship is terrible, Your Honor.
Right. Like I said, sorry, Your Honour, by way of clarification, they are Hutchings numbers with zeros after 1945.
That's what I thought. There was some.
And Ontario does that essentially. Well, Ontario has no net losses after 1945.
Right. I just thought it was not that these numbers were some approach to finding a common ground.
That was, I think, how my friend might have presented them. Ontario does not accept these numbers, and they're not the numbers that the minister adopted in his explanation.
But you can't tell me if they're 10, 20, 50,000% different.
No.
Ontario's different. All right. Okay. So let me then start with my question. So I think I got an answer to this question, but Ontario says start with net benefits,
Yes.
whatever they are. In Ontario's case, it would be with Ontario's assessment of what net benefits are. Apply bring forward rate
Well, yes, but Ontario first adds the 25%.
plus the 25%.
Which is net benefits. Sorry. No, you said net benefits, which includes the 25%.
Yes, I didn't say
No,
NCRRs.
you didn't.
Net benefits, apply a bring forward rate,
Yes.
and now you have
That's
something to look at through the lens of the other factors, partly, one of which is polycentric policy considerations.
the polycentric is the looking at this factor 3.
That's factor
Relations,
3,
yeah.
but there are other factors.
Yes.
You said you were prepared to look at. Do you do that after this exercise?
Yes.
Okay.
So I wanted just to summarize, this is my main first submission, Your Honor. The determination of a proxy past share by the plaintiffs is and can be nothing more than an ex post description, which is the result of a present decision that takes into account, no, actually, leave that there. There is no fixed share for the past. It says restored. There is no proxy share. There can be no contrived, hypothetical past augmentations resulting from a proxy share. The summation approach is not possible. It would require a determination of past augmentation decisions. The amount of past compensation is not determined by bringing forward past augmentation amounts that should have been paid or would have been paid. It is determined by bringing forward net benefits and making an augmentation decision in the present. And the bring forward rate that Ontario chooses reflects this process. You choose the bring forward rate that brings forward net benefits, not that brings forward hypothetical past augmentations. And Mr. Noga, my colleague, will address that further tomorrow.
Bring forward rate Ontario chooses reflects this process. You don't say it reflects your bottom line.
No.
It doesn't reflect the process, does it? You just choose a bring forward rate.
Well, Mr. Noga will get into this, but the bring forward rate is a rate that allows you to assess all the net benefits that occurred at different years in the past in one go in the present. You give them a common denominator.
Mhm.
So that's what you're doing. And the way you do that, according to the economists, is choose,
A bring forward rate.
well, you choose a bring forward rate, but that's the no risk rate. And the no risk rate is the government rate. So that's why Ontario chooses that rate. It's not because it ends up with a lower number, it's because that's how you get to weigh all these different times in one go. So, having been a bit negative, Your Honour, and saying that the plaintiff's position doesn't work, I'm going to say that my second main submission is that Restore actually directs what Ontario does. It directs Ontario's approach. The place to start is the interpretation. Right, mate? So this is back to paragraph 289 of Restore. So tab 1, page 8460, paragraph 289, under the heading, the nature of the treaty promise. Third line only? Well, yeah. At the end of the line, the fact of the matter is that the augmentation clause is not a promise on the part of the Crown to pay a certain sum of money. Rather, it is a promise to consider whether the economic conditions allow the Crown to increase the annuities without incurring loss, and, if they do, to exercise its discretion. I'm going to emphasise that that's the court's emphasis. Exercise its discretion. Promise is to exercise discretion and determine whether to increase the annuities, and if so, by how much. There's also a reference, which I won't take you to, which is paragraph 296. It says the same thing, but I will take you to paragraph 301 at page 8467. This is 301, 4 lines down again, yet it bears repeating. As I'm repeating this, that the augmentation clause is not a promise to pay a certain sum of money. It is a promise by the Crown to consider increases beyond $4 and, where appropriate, to exercise its discretion to increase the annuities. At this stage, a judicially calculated damages award would remove from the treaty implementation any exercise of Crown discretion and engagement between the treaty partners, the very essence of the treaty promise, respecting increases beyond $4. The very essence of the treaty promise is exercise discretion and engagement. That's what the treaty promise is, that's the interpretation. And we say that in order to understand what the Crown must do under the remedial direction in Restore, we need to understand what the Crown must do in a regular augmentation decision. Ontario's position is that the determination of past compensation is the same in nature as that which occurs in regular augmentation decisions. So I'm going to take you through.
I thought you just argued the opposite of that.
It's the same in nature. It's polycentric. It takes into account 4 of the same 5 factors. Same in nature meaning polycentric. So what we do with the past compensations, we bring everything forward, then we do the same polycentric nature of a decision.
And you say that in the future, you just take out the bring forward rate.
Yes. Depending on the length of the period.
Depending on the length of the period.
If it's 5 years, 10 years, maybe you use.
Okay.
So now we move to the implementation of the augmentation clause. Must be done honourably. This means diligently. Must be done purposively. Now, rather unhelpfully, Restore did not say the purpose is XXX, whatever, and set it out. But the reasons do indicate that the purpose is to share in the wealth of the land if it proved profitable. But I submit the purposes. And we take that from the factors to consider in the discretionary determination. So as the last of the factors referring to the honour of the Crown and the sacred promise. So that's paragraphs 197, 271 and 309. There are a couple of others, paragraphs 13 and 125, which I'll take you to. The compendium tab 1, page 8434, 8434, paragraph 13 of Restore. And we're looking for halfway down doing so. Doing so will require each party, but especially the Crown, to recall the purposes behind the treaty promises. The Robinson treaties are not merely transactional instruments about the exchange of money for a tract of land. They are living agreements embodying a relationship nurtured over many years before 1850 and requiring ongoing renewal into the future. Your Honour, this informs our understanding of what the purpose of the augmentation clause is, in order to implement purposively. The next paragraph is 125 at page 8438. Another reference to the purpose. The wording of the augmentation clause must be considered in the context of the purpose of the Robinson treaties as a whole. Under the treaties, the Anishinaabe ceded their interest in identified lands, were granted reserved lands to live on, retained treaty rights to hunt and fish, and were promised a lump sum of money and a perpetual annuity. I bring these to you for completeness in relation to understanding of the purpose of the augmentation clause.
Thank you.
Restore also said that the Crown must exercise its discretion liberally and justly for all its subjects. Your Honour, the court nowhere in Restore says that the amount must be liberal. It says that the exercise of discretion must be done liberally. There's the one reference in paragraph 180 to the Court of Appeal reasons, quoting the Court of Appeal, that says liberal and just. But that's the Crown being liberal and just, not the amount. It says the Crown being liberal and just.
Is this a new definition of splitting hairs?
No. And by next,
So the Crown must be liberal and just in determining an amount,
yes.
but the amount need not be liberal and just.
Well, yes. The amount, I want to explain what.
I probably don't need it to understand this, but it does seem to be an exercise.
No, Your Honour, it's important because the court didn't say the amount should be liberal and just. So I submit here that should be borne in mind. And secondly, it did say what liberally and justly means. So I want to take you through what it said it means. It is important because it goes to the nature of the Crown's decision making. So it makes the decision polycentric. It means that the Crown has to consider all His Majesty's subjects. I'll take you to
Sorry, it makes
it.
the requirement that the Crown's exercise be liberal and just makes the Crown consider.
Yes, that's right, sir. I wasn't clear. Exercised liberally and justly means the S is referring to that requirement. So, Restore Compendium tab 1, page 8442, paragraph 181, as I explained below. It's at the end, 4 lines from the bottom. As I explained below, the sharing is to be effected by an exercise of Crown discretion that reflects the honour of the Crown and abides by the Crown's promise to the Anishinaabe, quotes, to deal liberally and justly with all his subjects, having regard to the relative wealth and needs of all the Crown's subjects, signatories and non-signatories alike. Next, is paragraph 296. At page 8464. This discretion, 3 lines down on the, or 4 lines on the compendium. Paragraph 296. This discretion.
Go ahead.
Okay. This discretion must be exercised honourably, but also in accordance with Her Majesty's desire to deal liberally and justly with all her subjects. That's the court's underlining, under with all her subjects. To do justice to the Anishinaabe treaty partners and Her Majesty's other subjects. Accordingly, and the word accordingly is what ties liberally to the next part of the quote, the polycentric decision. Accordingly, in exercising its discretion, the Crown will have to engage in complex polycentric decision-making that weighs the solemnity of its obligations to the Anishinaabe and the needs of other Ontarians and Canadians, Indigenous and non-Indigenous alike. So this is the court saying liberally and justly means weighing needs of Anishinaabe and non-Anishinaabe in a polycentric decision. And I'll go back, please, Your Honour, to paragraph 294. Which is, starts on 8462, but on 8463, 5 lines down. The amount by which the Crown might increase the annuity is a polycentric and discretionary determination that will inevitably reflect many social, economic and policy considerations that may change over time. So I just wanted to draw the line there between liberally and justly and many social, economic and policy considerations. To help the Crown with this polycentric determination, the court set out 4 factors at 197. I'll just run through them quickly. Number of treaty beneficiaries and their needs. Benefits the Crown has received from the territory and its expenses during the relevant time frame. The wider needs of other Indigenous populations and the non-Indigenous populations of Ontario and Canada. Finally, the principles and requirements flowing from the honour of the Crown, including its duty to diligently implement its sacred promise to share in the wealth of the land if it proved profitable. This is the court helping the Crown with the polycentric determination by setting out 4 factors to take into account. These are the things that the Crown must consider when determining an augmentation if it can't be agreed. I want to address, Your Honour, the discussion between the court and Ms. Angelova from last week. Ontario submits there is no ledger of amounts owing under these 4 factors or elsewhere. There is no ledger of losses carried forward under these 4 factors. There's no ledger of harms. The court said the Crown must consider needs. It did not say needs and continued harms. More than that, the obligation is not to meet all needs. It is not a breach of the treaty obligation or an honourable obligation if there are some needs unmet. There is no carry forward of an unaugmented annuity. In the same way, the Crown does not carry forward losses, negative expenses.
You mean in the calculation of net benefits or a calculation of Crown benefits?
Yes, between one augmentation period and another. The determination starts again. Paragraph 197, the court said the Crown must, quote, must consider these 4 factors. They're clearly, I submit, considerations. 4 factors are considerations. To be clear, Ontario does not take the position that Anishinaabe legal principles, which we say come into these 4 factors, are not constraints. Ontario doesn't say that they are not constraints. They are indeed constraints in the judicial review sense. And my friend, my colleague, Mr. Rankin, will address that further. So calling them considerations doesn't mean we say they are not constraints. These four factors are what apply in a regular augmentation decision. These are decisions for the future, and they provide some guide to what, well, the Crown must decide in respect of past compensation. The Restore Court provided three guides about the meaning of these four factors. In respect of Crown benefit, we're not talking about general non-Indigenous benefit. I'm not going to take you, there are a couple of references, I'm not going to take you to them, but paragraph 285 at page 8458. Paragraph 285. The Crown has derived enormous economic benefit. Don't worry, mate. And then in paragraph 197, there are three references, 197, 271, 309. The factor, one of the factors, the court says, sacred promise to share the wealth of the land if it proved profitable. I say that profitable is an indication of who accrues the net benefits. That word suggests the Crown as a single entity that engages in a market. Profitable. Similarly, the court said the Crown must consider increases when it can do so without incurring loss. Loss is another word that suggests a single entity that engages in the market, not broad non-Indigenous benefit.
I'm not sure what your point is here. What are you distinguishing when you say a single Crown engaging in the market versus what?
Versus all, just by way of example, all economic rents taken up by non-RS, non-Robinson Superior Islands. Private sector,
Resource extractor.
yes, other Indigenous people with companies, so on.
So this is the rents argument.
Yes. The second guide, I've already noted that sharing is not a fixed percentage. And this might be a good place to stop, Your Honour, because I have a third guide which runs across several pages. I do wonder, Your Honour, and it's been discussed with a couple of my friends whether we might start early tomorrow. I do think I'm doing reasonably well, and maybe we can make up time if we do that.
I was hoping you'd raise that. What's your proposal?
9 a.m.
Right?
I
And
haven't,
go ahead.
I haven't discussed this with all my friends, just a couple, so it might be worth canvassing everyone.
Count yourself within the friend group if you discuss it with you.
I don't see a lot of friends, Your Honour.
The proposal is 9 o'clock start tomorrow. How does that work with everyone?
Yes, that's fine.
I don't know if this is on the record or not, I'm perfectly fine with a 9 a.m. start. To be honest, Justice Hennessy, I'm personally skeptical that we'll get through the whole day. And I just wonder whether people have already made changes to their flights. We had originally expected to carry on to Friday. I certainly understand my friends, Mr. Schachter and his group's concern. They don't want to start on Friday and understand that. But I wonder whether we still should be leaving part of Friday open in case we do need to spill over. I'm just wondering if people have changed their flights already or whether the parties agree with that.
Leave it open. Your Honor, we could leave Friday open, perhaps.
So I think, Ms. Evans, are you saying you're afraid that we won't get through it in a day?
That's right. I'm happy to start at 9, but let's be honest, even if we start at 9, from my own experience, having been up there where there's questions and what have you, certain things that were raised that weren't even on the agenda, I just don't want to say, let's start at 9 and then feel like we need to rush to get through.
Okay.
Yeah, it's just a thought. I wondered if people still have Friday open. What I'm suggesting is it might be possible for Ontario to carry over into Friday if they need to. It doesn't mean the First Nations have to go on their reply already. I'm just wondering what people's thoughts are about that. Because if they tell me, no, we've already changed flights, we can't do on Friday, then absolutely, let's start at 9 a.m. and let's all be prepared to stay late if we need to.
Okay.
We are here. We're not going anywhere. We'll be here Friday if needed.
Okay.
Change our flights, we can change them back.
The same position. I can change them back.
All of you who are in Toronto can change so easily. Well, I'd just like your best estimate, Mr. Ogden. If we started at 9, what do you think? I'm just going to ask Mr. Ogden for an estimate. Then I'd be happy to hear from you.
And at the end of tomorrow, if we start at 9, Your Honor.
Okay. Some advice happening here. Subject to what I hear, then I would not change my flights again.
Yeah. Great.
My flight takes me up Friday morning, but without room for a hearing. I can stay as late as we.
And I may have thrown a wrench in things by suggesting that Ontario might need more. If Ontario is committed that they can finish by the end of the day tomorrow, obviously that's up to them.
Thank you. Bass, anything?
Yeah, I mean, certainly we want everyone to have as much time as they need, so we don't want anyone to feel rushed. We're content to start early tomorrow and go later. We're also able to make arrangements to ensure that we're represented here on Friday or a portion of Friday morning if we require it.
Thank you. During your consultation, Mr. Ogden repeated that he thought if we started at 9, that he had a good confidence or some confidence that he could finish by end of day.
Yes.
All right. Then we will break now for the day and we will start at 9 tomorrow. Mr. Bass, is that?
Yes, might we also have a brief conversation off the record?
Yes, thank you. So we'll close court. Thank you. All right.
Court is adjourned until tomorrow at